connecting this back to our previous discussion about escalation, it is difficult for plaintiffs in this context to actually succeed on these types of claims because the standard is pretty defendant-friendly, board-friendly, if they did not consciously fail in their duties of oversight, if they didn't turn a blind eye to compliance violations, or if they consciously failed to remediate known failures. But even with that friendly standard, you still have to be able to show that they were properly informed of the relevant risks, that they were kept up to date. And that's where the escalation that Arlene was talking about is so essential, because without that communication from the front line to the management to the board, you won't be able to say that they actually fulfilled their oversight obligations. So it's been a kind of a challenge for plaintiffs in this area to actually get liability against companies or boards. But by no means does that mean this is not a huge challenge for companies that are not actually implementing cyber defenses, don't have an incident response plan in place, are not communicating properly to the market and their shareholders about their risks. Another challenge in this area for data breaches specifically is whether individual plaintiffs, victims whose data might have been captured in a data breach or ransomware attack, actually have standing to sue. For the litigators on the line, you know that in order to bring a lawsuit in federal court, you need to show that I particularly was injured in a concrete and actualized way. In the data breach context, some courts have said the future risk that you'll be subject to identity theft because of a data breach, for example, is too speculative to count as an injury that gives you standing to sue. Other courts have gone the other way, saying, well, if it's very sensitive information, if it was a really bad actor that took it, and there's some evidence that they're using it in this way, you might have an injury. In the ransomware context, which is a very much of an in development phase of litigation, you'll often see customers of companies that were victimized by a ransomware attack, or even customers of the victimized company, trying to bring suits for things like negligence or breach of contract or unjust enrichment. And they've met with varying levels of success. You need to first establish that the company had a duty to you, which might be contractual, it might not be in some cases. You have to show that they have a duty to prevent cyber attacks, which is probably a little bit easier to show, especially now given the threat environment that we're in. But it's been kind of a mixed bag so far for plaintiffs in this area as well. But there's a lot more opportunities for class action, securities claims like you mentioned, Paul, based on your company's disclosures about their cybersecurity practices. If they were overselling it and it turns out, wait, there actually are gaps that they knew about or should have known about, there's exposure there. And one thing I just wanted to go back to that we've kind of talked about throughout, and this relates to the SEC really is looking into whether companies will only disclose the hypothetical risk of cyber incidents in their risk disclosures, for example, when they know, no, you actually suffered from a material incident, you didn't disclose it, and now you're putting it out into the market that, well, we could suffer an incident in time without actually disclosing that they did suffer one. So that can cause some issues and potentially lead to SEC enforcement actions, as we've seen more in the recent past.